Most crimes disappear. A window is replaced, a police report is filed, the stolen money is written off, and before long, almost no one remembers that it ever happened. On June 3rd, 1961, there was every reason to believe this crime would meet the same fate. Before sunrise, someone broke into the Bay Harbor pool room in Panama City, Florida. They forced open a window. They pried open the cigarette machines. They emptied a jukebox of its coins. They left with a few bottles of beer and only a handful of cash. By any measure, it was a small burglary. No one was killed. No one was injured. There was no nationwide manhunt. Just another case added to a growing stack of police reports. But history has an odd habit. Sometimes it hides inside events so ordinary that no one notices them until years later. Because this burglary would eventually reach the Supreme Court of the United States, reshape the meaning of the Sixth Amendment, and change the rights of every American accused of a serious crime. All because of one man. I'm Jason Thomason, and this is the History Podcast. By mid-morning, police had a name. Not because they had fingerprints, and not because they had recovered the stolen property, not because anyone claimed to have witnessed the burglary itself. Instead, investigators were led to a man who had been seen leaving the area carrying a bottle of wine, several bottles of beer, and pockets that appeared to be unusually full of change. His name was Clarence Earl Gideon. At first glance, Gideon did not look like someone destined to change American constitutional law. He was 50 years old, thin, soft-spoken, weathered by decades of transient labor. His formal education had ended around the 8th grade, though accounts do differ slightly on precisely when he left school. Like many Americans born into poverty during the early 20th century, education had been a luxury that life seldom afforded. He spent much of his adulthood drifting from town to town, taking whatever work he could find: construction, manual labor, odd jobs that rarely lasted very long. The public record paints a picture that is very difficult to romanticize. He had previous convictions. He had spent time in prison before. He lived on the margins of society where stable employment was scarce and encounters with law enforcement were hardly unusual. In many retellings of this story, Gideon becomes either a folk hero or a symbol of systemic injustice, and neither description quite fits. He was simply a man with a complicated life, and as we've tried to illustrate several times over the course of this podcast, history often belongs to complicated people. Police arrested Gideon and charged him with breaking and entering with intent to commit petty larceny, a felony under Florida law. The evidence against him was largely circumstantial. A local witness, Henry Cook, claimed to have seen Gideon leaving the pool hall around dawn carrying a bottle of wine and beer. Prosecutors believed that testimony, combined with Gideon's possession of coins, was enough to persuade a jury. Now, whether it actually proved guilt beyond a reasonable doubt would become a question discussed by legal historians for decades, but that question wasn't yet the important one. The important question hadn't even been asked. Weeks later, Gideon entered the courtroom of the Bay County Circuit Court. The courtroom itself was quite unremarkable. Wooden benches, a judge elevated above the attorneys. Everything appeared exactly as Americans imagine a criminal courtroom should, except for one detail. The man accused of committing the felony stood alone. No attorney beside him, no investigator, no legal advisor, just Clarence Gideon. When his case was called, he addressed the judge respectfully. He explained that he was not prepared to defend himself. He requested that the court appoint an attorney. Now, today, that request sounds almost automatic, and many of our listeners may struggle to imagine any other outcome, but in 1961, what seems obvious today was anything but settled law. The judge listened respectfully, and then he declined. Under Florida law, he explained, appointed counsel was generally only required in capital cases, cases in which the defendant could face the death penalty, and this wasn't one of them. The judge explained that if Gideon wanted a lawyer, he would need to hire one. But he couldn't. The exchange occupied only a few moments. No raised voices, no dramatic objection, no constitutional debate, just an ordinary procedural ruling delivered in an ordinary courtroom. Yet, it would become one of the most consequential judicial refusals in American history. Imagine for a moment what that meant. Not emotionally, but practically. Across the room sat a trained prosecutor, someone who understood the rules governing evidence, who knew when to object, how to question witnesses, how to frame arguments before a jury. On the opposite side stood a laborer with no legal training whatsoever. Modern audiences sometimes assume that representing yourself simply means just telling your side of the story. A criminal trial is nothing like that. It is a contest governed by hundreds of procedural rules, many invisible to anyone outside the legal profession. When can hearsay be admitted? How should jurors be instructed? Which questions may be asked on cross-examination? When should objections be raised? Miss one opportunity, and it may never return. A courtroom has often been compared to a game, but perhaps that comparison misses something important. Games begin only after both players learn the rules. Gideon was expected to discover them while already losing. The trial itself lasted only a single day. There would be no nationally known attorneys, no courtroom packed with reporters, no television cameras waiting outside the courthouse doors. To everyone involved, this appeared to be just another routine felony case moving through an already crowded docket. The prosecution called its witnesses first. Among them was Henry Cook, a local resident who testified that he had seen Clarence Gideon near the Bay Harbor pool room in the early morning hours of June 3rd. According to Cook, Gideon emerged from the direction of the pool hall carrying a bottle of wine, several bottles of beer, and what appeared to be pockets weighed down with coins. For the state, that testimony helped tie together the burglary. The pool room had already reported missing beer. Coins had disappeared from the jukebox and cigarette machines. Gideon, prosecutors argued, had been seen with both. Now, it was circumstantial evidence, but circumstantial evidence is not inherently weak. Courts have long recognized that juries may infer guilt from a collection of facts, even when no witness claims to have seen the crime itself. Many criminal convictions rest on such inferences. Whether those inferences were persuasive was a question for 12 jurors. Whether Gideon was equipped to challenge them was another matter entirely. Acting as his own attorney, Gideon cross-examined the witnesses. Reading the transcript today, one cannot help but notice its uneven rhythm. There are moments when Gideon asks sensible questions, questions that reveal an intuitive understanding that eyewitness testimony should be tested rather than just accepted at face value. Yet, those moments are often followed by missed opportunities that an experienced defense attorney might have recognized immediately. No one had taught him how to impeach a witness. No one had explained the strategic value of building a theory of the case before questioning began. No one had prepared him for the countless decisions that trial lawyers make almost instinctively after years of practice. This is not to say that an attorney would have necessarily secured an acquittal. History offers no such certainty. But the point is much simpler than that. A trained advocate and an untrained defendant do not enter a courtroom on equal footing. When the time came to present his own case, Gideon called witnesses on his behalf. He questioned them himself. He argued to the jury himself. And finally, standing alone before 12 fellow citizens, he delivered his closing argument. We do not know exactly what every juror thought as they listened to Gideon. Perhaps some admired the determination of a man willing to defend himself. Perhaps others saw only a defendant with a criminal record attempting to avoid responsibility. Jurors rarely leave behind detailed explanations of how they reach their verdicts. The deliberation room keeps its own secrets, but what we do know is that the jury returned with a verdict of guilty. The sentence followed soon afterward. 5 years in the Florida State Prison. Had the story ended there, Clarence Gideon would almost certainly have disappeared into history. Florida prisons housed thousands of inmates during the early 1960s. Most served their sentences in relative anonymity. Their convictions attracted little attention beyond family members and local officials. There was every reason to believe Gideon would become one more forgotten name in a prison ledger. Instead, prison gave him something he had not possessed during his trial: time. Prisons operate according to routines so repetitive that days begin to lose their individual character. Meals, work assignments, counts, lights out. Then the cycle begins again. For some inmates, the monotony becomes unbearable. For others, it creates an unexpected opportunity to think. Gideon read. He visited the prison library. He studied law books that would have seemed almost impenetrable to someone without formal legal education. The language was dense. The precedents stretched back decades. Citations filled the margins like a code written for specialists. Yet he persisted, not because he expected to become a lawyer, but because he believed something had gone wrong. And this distinction matters. It's tempting looking backward to imagine Gideon setting out on a grand constitutional crusade. The historical record suggests something far more modest. He just wanted another trial. He believed he should have had a lawyer. Those are not the same thing. One seeks to reshape American law. The other seeks another chance. History is funny because it sometimes begins with ambitions much smaller than the consequences they eventually produce. As Gideon read, he encountered decisions from the Supreme Court of the United States. Some appeared encouraging, others did not. One case in particular stood in his way. Nearly 20 years earlier, the Supreme Court had decided Betts v. Brady. In that case, the court concluded that the Constitution did not require states to appoint counsel in every felony prosecution. Instead, judges were to examine the specific circumstances of each case, appointing attorneys only when quote unquote special circumstances made the absence of counsel fundamentally unfair. To lawyers, the opinion represented a nuanced constitutional rule. To prisoners like Gideon, it meant something much simpler. Whether you received a lawyer could depend upon where you were prosecuted, which judge heard your case, and how that judge interpreted your circumstances. Justice, at least in this corner of constitutional law, did not always look the same from one courtroom to another. At some point, perhaps after weeks of reading, perhaps after months, Gideon made a decision. He would write directly to the Supreme Court. The idea bordered on the unbelievable. The highest court in the nation received thousands of petitions each year. Most were denied without comment. Many came from experienced attorneys representing corporations, governments, or well-funded organizations. Clarence Gideon had none of those advantages. No lawyer, no legal secretary, no law office, no reputation, only a prison stationery and a pencil. And the conviction that the Constitution had something to say about what had happened to him in that Florida courtroom. The letter was remarkably simple. There was no soaring rhetoric, no theatrical language, no attempt to impress the justices with legal scholarship. Instead, Gideon described what had happened. He explained that he had asked for an attorney. He explained that the request was denied. He argued that the Constitution entitled him to more than a trial. It entitled him to a fair one. Gideon folded the papers, addressed the envelope, and sent it to Washington. He had no way of knowing that somewhere inside the marble walls of the Supreme Court, someone would soon open that envelope, or that one handwritten petition from an inmate with an eighth grade education would persuade the court to reconsider one of its own constitutional precedents. The window at the Bay Harbor pool room had been broken months earlier. Now, quietly, almost invisibly, another one was about to crack. If Clarence Gideon expected an answer, history doesn't tell us. Perhaps he did. Perhaps he simply believed he had exhausted every option. Or perhaps, like countless prisoners before and since, he understood that writing one more letter cost him nothing but time. Whatever his expectations, the odds were not in his favor. Every year, the Supreme Court of the United States receives thousands of petitions asking it to review lower court decisions. Most are denied without explanation. A denial does not necessarily mean the court agrees with the outcome below. It often means only that the case doesn't present the kind of legal question the justices have chosen to resolve. For every case argued before the court, hundreds quietly come to an end with a single notation: certiorari denied. Those cases disappear almost as quickly as they arrive. Gideon's should have been one of them. The petition itself reflected its author. It was handwritten, simple, unpolished. There were no elaborate constitutional theories, no legal quotations from precedent, no polished prose designed to persuade seasoned jurists. Instead, Gideon just described what had happened in plain language. He had been charged with a felony. He had asked the trial judge to appoint an attorney because he couldn't afford one. The request was denied, and he had to represent himself. He was convicted, and he believed that conviction violated the Constitution. To modern readers, accustomed to the legal briefs running dozens or even hundreds of pages, Gideon's petition can feel almost laughable in its simplicity. Yet, beneath its modest presentation lay a question that had troubled judges and scholars for decades. What does the Constitution actually promise someone accused of a crime? Not what seems fair, not what individual states choose to provide. What does the Constitution require? When the petition arrived in Washington, it entered a process that was already familiar with disappointment. Law clerks reviewed filings, procedural requirements were checked, recommendations were prepared. Most petitions never reached the stage of full argument before the court. Many raised questions that had already been answered. Others involved disputes too narrow to warrant national review. The court, in fairness, could not hear them all even if they had wished to. So why Gideon? The answer was not found in who he was. It was found in the question he asked. For nearly 2 decades, one Supreme Court decision had shaped the landscape of criminal justice in state courts across the nation. That decision was Betts v. Brady, handed down in 1942. The facts of Betts differed from Gideon's, but the constitutional issue was strikingly similar. Smith Betts, a poor farmhand in Maryland, had also requested appointed counsel in a felony prosecution. His request was denied, and he too had to represent himself at trial. When the case reached the Supreme Court, the justices faced a difficult question. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. I mean, the words seem direct enough, but there was a complication. When the Bill of Rights was adopted in 1791, it restricted only the federal government. States operated under their own criminal procedures unless a constitutional provision had later been interpreted to apply to them through the 14th Amendment. By the middle of the 20th century, the court had already concluded that many protections in the Bill of Rights limited state governments as well. Whether the right to appointed counsel belonged on that list remained unsettled. The court in Betts answered cautiously. Rather than declaring that every poor defendant charged with a serious crime must receive an attorney, the justices adopted a more flexible standard. Appointment of counsel, they reasoned, depended upon the circumstances of each case. Was the defendant unusually young, unable to understand the proceedings, faced with especially complicated legal issues? Only under such, and I quote, special circumstances would the Constitution require a lawyer. To its supporters, the decision respected the diversity of state criminal justice systems. To its critics, it created uncertainty. The Constitution, they argued, should not mean one thing in Maryland and another in Florida, nor should the availability of counsel depend upon the personal judgment of an individual trial judge. Legal scholars debated the decision for years. Some praised its flexibility. Others questioned whether a criminal trial could even be fundamentally fair when one side possessed professional legal training and the other did not. The debate remained largely academic until Gideon's letter arrived. It's tempting to imagine the justices immediately recognizing the significance of Gideon's petition. However, history is rarely so dramatic. The Supreme Court is an institution, it's not a stage. Cases move through procedures. Memoranda are written. Recommendations circulate. Questions are discussed. No single dramatic moment transformed Gideon's handwritten petition into a constitutional landmark. Instead, something quieter happened. Enough members of the court concluded that the issue deserved another look. And that alone was extraordinary. The court had no obligation to reconsider one of its own precedents merely because a Florida prisoner disagreed with it. Courts value stability, and precedent exists for a reason. Overturning an earlier constitutional decision is never done lightly. If Betts v. Brady was to be considered, the justices needed to believe that more than one man's conviction was at stake. They needed to believe that the law itself might be wrong. In the autumn of 1962, the court agreed to hear Gideon v. Wainwright. With that decision, Clarence Earl Gideon ceased to be merely an inmate challenging his conviction. He became the petitioner in a case that would ask the nation's highest court to revisit one of its own constitutional judgments. But another problem emerged almost immediately. The Supreme Court had agreed to hear Gideon's argument, but who exactly was going to make it? Gideon remained in prison. He had no money, he had no legal team, he had no influential supporters waiting outside the courthouse. The irony was difficult to ignore. A case about the importance of legal representation had arrived before the Supreme Court with no lawyer to argue it. The justices would have to solve that problem before they could solve the constitutional one. And in doing so, they would summon a lawyer whose name would become inseparable with Gideon's own, a Washington attorney named Abe Fortas. He didn't know it yet, but he was about to receive one of the most consequential assignments of his career. When Clarence Gideon's petition reached the Supreme Court, it carried with it a problem that went beyond the question of whether one man had been treated unfairly. The court had agreed to hear his argument, but Gideon was still sitting in a prison cell. He had no office, no legal staff, no courtroom experience, no way to stand before 9 Supreme Court justices and explain why he believed the Constitution had been violated. The irony was impossible to miss. A case about the importance of having a lawyer had arrived before the Supreme Court without one. The court had faced this situation before, and in cases involving individuals who could not afford representation, it sometimes appointed attorneys to present arguments so that the legal issues would be fully developed. The goal was not to decide the case in advance, it was to make sure the court heard the strongest possible arguments from both sides. And so the search began for someone to represent Clarence Gideon. The person chosen would not be a famous criminal defense attorney. He would not be a lifelong advocate for prison reform. He would not even begin the case as someone looking for an historic moment. His name was Abe Fortas. Fortas was almost the exact opposite of Clarence Gideon. Where Gideon had spent much of his life moving from job to job and place to place, Fortas had built a career in the center of American power. He was a Washington lawyer, educated, well connected, comfortable navigating the language and traditions of the legal world. He had argued before the Supreme Court before. He understood the rhythm of appellate advocacy, the careful preparation, the precise wording, the ability to reduce a complicated constitutional dispute into a question that 9 people could answer. But the appointment placed him in an unusual position. He was not defending Gideon because he had chosen the client. He had not met Gideon through a law office. He had not been hired. Instead, the Supreme Court itself had placed their names together. A prisoner from Florida, a Washington attorney, and a constitutional question that had been waiting for an answer. When Fortas began reviewing the case, he encountered something that lawyers often find when they examine old convictions. The most important questions are not always the ones that first appear. At first glance, the case was about Clarence Gideon. Had he been guilty? Had the evidence been enough? Had the trial been conducted fairly? But Fortas quickly recognized that the Supreme Court was not being asked to decide whether Gideon committed the burglary at the Bay Harbor pool room. That question belonged to a jury in Florida. The court had been asked something much larger. Could a state imprison someone after a felony trial in which that person had no lawyer and no ability to afford one? That was the question hidden inside Gideon's handwritten petition. The challenge Fortas faced was not simply convincing the justices that Gideon deserved sympathy. Sympathy has limited power in constitutional law. The Supreme Court does not rewrite constitutional rules because one person has a compelling story. The argument had to be larger than Gideon. It had to explain why the rule itself was wrong. For nearly 20 years, Betts v. Brady had governed these cases. The decision had attempted to draw a very careful line. The Constitution did not require appointed counsel in every felony case, the court had said. Instead, judges were expected to consider whether a particular defendant faced circumstances so difficult that a fair trial was impossible without legal assistance. The problem was that special circumstances could mean different things in different courtrooms. A defendant's fate could depend on the judge assigned to the case. One courtroom might view a lack of education as a special circumstance where another might not. One judge might believe a defendant was capable of defending himself, and another might reach the exact opposite conclusion. The rule was flexible, but flexibility can sometimes create uncertainty, and uncertainty in criminal justice carries consequences. Fortas understood that asking the Supreme Court to overturn Betts v. Brady was not a small request. Courts depend on precedent. The law cannot function if every decision is treated as temporary. People rely on judicial decisions. Legislatures rely on them. Lower courts follow them. A precedent is not simply a sentence written in a book, it becomes part of the structure of government. And to overturn one is to admit that the structure may have been built incorrectly. To be fair, the court had done this before, but it did so very carefully. Rarely. Only when the justices concluded that an earlier interpretation could no longer stand. Fortas now had to convince them that Betts was one of those decisions. As Fortas prepared his argument, he returned again and again to the words of the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The language was not complicated. The debate was. What did the right mean? Was counsel merely one possible protection among many? Or was it the foundation that made the rest of the trial process meaningful? Because a criminal trial is not simply a place where facts are presented. It is a system of rules, and those rules are written in a language that few people understand without training. A person unfamiliar with the law may know they are innocent. They may know the witnesses are wrong. They may know the story being told about them is incomplete. But knowing something is wrong and knowing how to prove it inside a courtroom are two very different things. Meanwhile, Clarence Gideon waited. He didn't know exactly what was happening in Washington. He did not know how Fortas was preparing. He did not know whether the justices were persuaded by his argument. From his perspective, the case was still a letter sent from a prison cell. The distance between Florida and Washington was measured not only in miles, but in power. One man had asked the government to listen. Now, the government was preparing to answer. On January 15th, 1963, the Supreme Court heard oral arguments in Gideon v. Wainwright. The courtroom was filled with the rituals of the institution. The justices took their seats, attorneys prepared their notes, and before the court was a question that had divided judges, scholars, and lawmakers for decades. Was the right to a fair trial possible without the right to a lawyer? The answer would not come immediately. The judges would take the case under consideration, and behind closed doors, they would debate. And Clarence Earl Gideon would wait once again. This time, however, the decision waiting for him would not come from a jury in Florida. It would come from the highest court in the United States. The Supreme Court courtroom has a way of making even the most important questions feel ordinary. There are no dramatic sound effects, there's no flashing lights, there's no indication that history is being made. A lawyer stands at a wooden podium, 9 justices sit above him, questions are asked, answers are given. The machinery of the law moves forward quite quietly. On January 15th, 1963, that machinery turned its attention to Clarence Earl Gideon. The question before the court was deceptively simple. Does the Constitution require states to provide attorneys for people who cannot afford them when those people are charged with serious crimes? But beneath that question were decades of disagreement about the role of government, the meaning of fairness, and the limits of constitutional power. Abe Fortas was not there to argue that Clarence Gideon was innocent, and that distinction matters. The Supreme Court was not a second jury. It was not reviewing whether Gideon had committed the burglary at the Bay Harbor pool room. It was reviewing the process that led to his conviction. Fortas's argument rested on an idea that sounds obvious today, but was deeply contested at the time. A criminal trial is not truly fair when one side has a trained legal advocate and the other side doesn't. The issue was not whether every defendant would make good use of a lawyer. The issue was whether the government could take away a person's freedom after a proceeding where that person was left to navigate the legal system alone. The state of Florida saw the question differently. The state was not arguing that lawyers were unimportant. Florida, like many states, had long recognized the value of legal representation. The disagreement was constitutional. Did the 14th Amendment require every state court to appoint counsel in every serious criminal case? Or did states have room to design their own procedures? This was not merely a debate about lawyers, it was a debate about federalism. How much authority should states have over their own criminal justice systems? How much uniformity should the Constitution demand? The state relied heavily on precedent. Nearly 20 years earlier, the Supreme Court had decided Betts v. Brady, and that decision had rejected the idea that the Constitution required appointed counsel in every felony case. Instead, it created a case-by-case approach. Supporters of that approach believed it allowed judges to consider individual circumstances. Not every defendant faced the same challenges. Not every trial involved the same complexity. Not every person accused of a crime was equally incapable of defending themselves. A flexible standard, supporters argued, allowed courts to recognize truly unfair situations without creating a rigid national rule. But Fortas argued that the flexibility of Betts was precisely the problem. A constitutional right, he suggested, should not depend on geography. A person accused of a crime in one state should not have fewer protections than a person accused of the same crime somewhere else. The Constitution was meant to establish certain guarantees that government could not simply choose to ignore. And among those guarantees, Fortas argued, was the assistance of counsel. Behind the arguments about legal doctrine was a more basic question. What does a trial actually require? For much of American history, courts have operated under the assumption that judges and juries could protect fairness even when defendants represented themselves. But critics of that assumption pointed out something difficult to ignore. The criminal justice system has become increasingly complicated. Rules of evidence have grown more technical. Procedures have become more demanding. And the gap between a trained attorney and an unrepresented defendant had become much larger. A courtroom was not simply a place where truth emerged naturally. It was a place where truth had to be discovered through a structured process. And the process had rules. The justices listening to these arguments were not starting from a blank page. They carried with them years of experiences, competing judicial philosophies, and their own views about the relationship between the Constitution and the states. Among them was Justice Hugo Black. Black had long believed that many protections in the Bill of Rights should apply fully to the states. He had dissented in Betts v. Brady, arguing that the right to counsel was fundamental. For Black, the words of the Sixth Amendment were not conditional. The right existed because the Constitution said it existed. Other justices had been more cautious. They worried about replacing the judgment of state governments with a single rule created in Washington. The question was not whether lawyers were helpful. Almost everyone agreed they were. The question was whether the Constitution required them. When the arguments ended, the justices returned to their private conference. The public would hear no immediate answer. The conference room would remain closed. No reporters would know what was said. No observers would know which arguments had persuaded which justices. Inside that room, the court faced a familiar but difficult task. When should an institution admit that a previous decision was wrong? Overturning precedent requires more than disagreement. It requires confidence that the law will be better, clearer, and more faithful to the Constitution afterward. The justices had to decide whether Betts v. Brady was a reasonable interpretation of constitutional law, or whether it had created a system where an essential right depended too heavily on chance. For Clarence Gideon, there was nothing left to do. The arguments had been made, the attorneys had spoken, the justices had heard the case, and a man who began this journey with a pencil and a piece of prison stationery had taken his question as far as it could go. Now he waited. Soon, the Supreme Court would announce its decision. And when it did, it would not simply decide what happened to Clarence Gideon. It would decide what happened to every person who stood accused of a serious crime and could not afford an attorney. On the morning of March 18th, 1963, the Supreme Court released its opinion in Gideon v. Wainwright. For most Americans, it was just an ordinary Monday. People went to work, children went to school, courts across the country continued handling the business of criminal justice. But inside those courts, a quiet change had begun. The Supreme Court had answered the question Clarence Earl Gideon had written about from a prison cell. The answer was unanimous. 9 justices had agreed. The Constitution requires states to provide attorneys for defendants who could not afford one in serious criminal cases. The opinion was written by Justice Hugo Black. For Black, the case represented something he had argued for years. Certain rights protected by the Constitution were not optional, depending on where a person happened to be prosecuted. The Sixth Amendment did not describe counsel as a privilege, it described counsel as a right. And in Black's view, the right was essential because the government itself possessed enormous power. A criminal prosecution is not a disagreement between equals. On one side, you have the authority of the state. The other side represents an individual whose liberty may be taken away. Without legal assistance, Black argued, the protections built into the criminal justice system could become little more than words on paper. The court's decision did not declare that every defendant was guaranteed a perfect defense. It did not promise acquittals. It did not erase the possibility that guilty people would still be convicted. The decision addressed something narrower and, at the same time, much larger. It addressed the fairness of the process. The court concluded that a fair trial could not depend upon whether a person had enough money to hire an attorney. A wealthy defendant and an impoverished defendant might face the same charge. They may sit in the same courtroom. They may face the same punishment. But without counsel, their ability to navigate the system could be dramatically different. The court had decided that difference mattered constitutionally. The reaction was immediate. Across the country, state courts and lawmakers now faced a very practical question. What happens next? A constitutional right had been recognized, but rights require institutions. They require funding. They require lawyers. They require systems capable of making real promises. The decision created a responsibility that extended far beyond the courtroom where Clarence Gideon had once stood alone. Every state now had to confront how it would provide representation for people who could not afford it. Some states already had systems in place, others had to build them. The modern public defender system, as Americans know it today, was shaped in large part by the demands created after Gideon. But the story doesn't stop there. In fact, the Supreme Court's decision did not immediately free Clarence Gideon. It did not declare him innocent. It did not erase his conviction. The court had ruled that his first trial was unconstitutional because he had been denied counsel. The remedy was not automatic freedom. The remedy was a new trial. This distinction is one of the most important and often overlooked parts of the story. The Supreme Court had not answered the question, did Clarence Gideon commit the crime? It answered, was the trial that convicted him conducted fairly under the Constitution? Those are very different questions. And now, they would return to Florida. When Gideon learned of the decision, he was still incarcerated. The man who had sent a handwritten petition to Washington had received the answer he hoped for. But his journey was not complete. He would have to walk into another courtroom. He would have to face another jury. He would once again confront the accusation that started everything. The difference this time was simple. He would not stand alone. Months later, Clarence Earl Gideon returned to court. This time he had a lawyer. His attorney was W. Fred Turner. a respected local attorney appointed to represent him during the retrial. The contrast with the first trial was immediate. Instead of questioning witnesses by himself, Gideon had someone trained in the law examining the evidence. Instead of trying to understand procedure while trapped inside it, he had an advocate who knew the rules. The prosecution presented its case again. The defense challenged it. The jury listened. And then, after considering the evidence, the jury reached its decision. On retrial, Clarence Gideon was found not guilty. The ending of the story is often presented as simple. A poor man was denied a lawyer, the Supreme Court corrected the mistake, justice prevailed, but history is rarely that neat. Because the question that follows Gideon v. Wainwright is not only whether the court recognized an important right, the question is whether the country has been able to fulfill the promise of that right. A lawyer is only the beginning. A meaningful defense requires time, resources, preparation, investigation. The ability to challenge the power of the state with something approaching equal strength. The decision in Gideon answered one question. It left another for every generation afterward. What does it truly take to provide justice? The story of Clarence Earl Gideon appears at first to have a satisfying ending. A man stands alone in a courtroom, he asks for help, he is denied, he writes a letter, the Supreme Court listens, the law changes, then he receives a new trial and walks away acquitted. It's almost like something you would see in a movie. It's the kind of ending that feels complete. But constitutional history rarely ends with a single decision. A Supreme Court ruling can change the law in a moment. Changing the reality created by that law can take generations. When Gideon v. Wainwright was decided in 1963, it answered a question that had divided courts for decades. But it immediately created new ones. If every person accused of a serious crime had a constitutional right to an attorney, who would provide those attorneys? How would they be paid? How would states ensure that representation was not merely available, but meaningful? The Constitution had recognized a right. The country now had to determine how to deliver it. Before Gideon, the legal landscape varied dramatically from one place to another. Some communities had established systems for appointing attorneys to represent the poor. Others relied on private attorneys who were assigned cases as needed. And in some areas, judges selected lawyers from the local bar. The quality of representation could depend heavily on location, resources, and local commitment. After Gideon, states had to confront the reality that criminal defense for the poor could no longer be treated as an occasional act of charity. It was now a constitutional obligation. The decades that followed produced the modern public defender system. For many Americans, the image of a public defender is familiar. A lawyer working in a government office, a crowded schedule, a courtroom full of cases, someone representing people who otherwise could not afford an attorney. But the development of public defense was not uniform. Different states created different systems. Some established independent public defender offices. Some continued relying heavily on appointed private attorneys. And then some developed some kind of hybrid model. The result was a system that reflected the same tension that existed before Gideon. The country had agreed on the importance of the right, but it continued debating the best way to fulfill it. And this is where scholars have often returned to the same question. What does the word counsel actually mean? If a person is assigned an attorney who has no time to investigate, no resources to prepare, and hundreds of other cases competing for attention, has the constitutional promise truly been fulfilled? Or is the existence of a lawyer alone enough? Different scholars and legal professionals have answered those questions differently. Some argue that Gideon was one of the most important advances in American criminal justice because it recognized that fairness cannot depend entirely on wealth. Others argue that the decision created an obligation that many systems have struggled to meet because the resources devoted to that defense often do not match the resources available to prosecution. The debate is not about whether lawyers matter. Almost everyone agrees they do. The debate is about what meaningful representation requires. More than 60 years after Gideon, the case remains one of the most frequently discussed decisions in American criminal procedure. Law students study it, courts cite it, public defenders invoke it, scholars continue examining its meaning. But perhaps the most interesting part of Gideon's legacy is not simply the rule it created, it is the question it forces society to ask. When the government accuses someone of a crime, what level of protection does that person deserve? Is a trial merely a place where evidence is presented and a verdict is reached? Or is it a process that must provide a genuine opportunity to challenge the power of the state? Return for a moment to that Florida courtroom in 1961. Clarence Gideon was not standing there because history had chosen him. He was not a famous activist. He was not a constitutional scholar. He was a defendant, a man accused of a crime, a man with a very complicated past, a man who may or may not have committed the act for which he was convicted. And that last question is important because Gideon v. Wainwright was never ultimately about whether Clarence Gideon was innocent. The Supreme Court never decided that. The jury at his retrial did. The constitutional question was different. Could the government take away a person's freedom through a process where that person lacked the tools necessary to defend himself? And the Supreme Court answered no. There is something remarkable about how this story began. Not with a landmark speech, not with a powerful attorney, not with a political movement. It began with a broken window, a small pool hall in Florida. A defendant nobody outside his community knew. A judge making a decision that was considered ordinary at the time. And a man in prison who believed that decision was wrong. The American legal system is built on an unusual idea. Ordinary people can challenge extraordinary power. A citizen can challenge a government agency. A defendant can challenge a prosecutor. A prisoner can write a letter to the Supreme Court. Most of those challenges fell, Most disappear without changing anything, but occasionally one survives. Occasionally, a person who seems powerless asks a question that a nation cannot ignore. Clarence Earl Gideon died in 1972. He lived long enough to see the world change because of the case that carried his name. He saw his conviction overturned. He saw his second trial end in acquittal. He saw the words he wrote from a prison cell become a part of American constitutional law. But his greatest legacy may not be that he won. It may be that he forced the country to confront an uncomfortable question. What does fairness require when the person standing alone cannot afford the tools needed to fight? The answer has never been simple. The debate continues. But the principle established in Gideon v. Wainwright remains. A courtroom may be where justice is decided, but justice cannot depend on whether someone can afford to enter it with help. This has been the History Podcast. I'm Jason Thomason. Thanks for joining me. We'll see you next time.